हे एवरीवन, वेलकम टू माय चैनल फीलियर जितेश। मैं आज आप लोगों के लिए पॉलिटी के लेक्चर्स बहुत ही एक फेमस कोचिंग के अपलोड कर रहा हूँ। प्लीज़ कोई स्ट्राइक कोई कंप्लेन मत कीजिएगा। ये सिर्फ उन लोगों के लिए हैं जो अफोर्ड नहीं कर सकते हैं। मैं पहले ही माफ़ी मांग रहा हूँ, बाद में आप लोग ये मत कहिएगा कि आप चोरी कर रहे हो, ऐसा कर रहे हो, वैसा करो। देखिए, मेरे को भी कहीं से मिले तो मुझे लगा कि उन स्टूडेंट्स के लिए डाल दिए जाएँ, लाइक जो अफोर्ड नहीं कर सकते। मैं भी उनमें से ही हूँ एक। मैं चाहता हूँ कि आप लोग इसका भरपूर इस्तेमाल करें, अच्छे से पढ़ें। दीज आर दी बेस्ट लेक्चर्स एंड मैं भी इससे पढ़ रहा हूँ, आप लोग भी इससे पढ़ो। एंड कोशिश करूँगा जल्द से जल्द सारे लेक्चर्स डाल दूँ। तो प्लीज़ अच्छे से पढ़िए। अब सही समय है सही से तैयारी करने का, तो अच्छे से तैयारी करिए। चलिए, आई होप यू विल लव दी लेक्चर्स। प्लीज़ लाइक शेयर एंड सब्सक्राइब माई चैनल।
Be cool but not cold. ठीक है सर, there is a difference. Very good. I know many cannot answer right now, but many can. This is a good sign because it's only the beginning. Okay, maintain this. अरे लिखने के लिए था. Only the articles which I discuss in the class should be tackled. Do not run after articles and articles. जो मैंने क्लास में कराए हैं, they are more than enough. And if you catch hold of them also, that is very. What? So, that is not reservation for women. See, Article 15, Clause 3, what it says? It says, क्या बोलता है 15.3? It says, yes, for the development of women and children, we can have special provisions. But nowhere it said what provisions. है ना? That is an enabling provision. Enabling means, since it is there, number of laws can be made. And one law could have been this. Okay, but then that will not require constitutional amendment. Understand? I mean, tomorrow, Parliament can make it compulsory. Every political party will fix 33% seats for their women candidate. वो अभी हुआ नहीं है. That may happen, but that will happen by the virtue of this article, not by this article precisely. No, that will not require constitutional amendment. यार एक बात सुनो, constitutional amendment तो तब होती ना, when you would have written that this much % of seats are reserved for women in political parties. वो तो आपने कहीं लिखा नहीं है. Option 1 is true. If that is to be done, constitutional amendment is required. इसमें आपने 15.3 पढ़ा था? Were you in class? What was the language? हाँ, where is it talking about elections in 15.3? अरे जल्दी बताओ यार, quick. Did it even use the word elections? No. So how can you say that this is giving this power? Though if that law is made, 33%, do we have 33% reservation right now? No. Arey, we don't have right now. In Parliament I'm talking about. नहीं है ना अभी तक. So there is no question of that. But then if you have to have it done tomorrow, then you will require a constitutional amendment. उसको आपको mention करना पड़ेगा constitution के अंदर. Understand, sir? Right now. Next. One more question. Sir, anti-defection law comes in which schedule? 10 or 8? Very good. 10. Anti-defection law has come twice. This time also it can come. What is schedule 8th? Do not wait for me to take everything. चलो अपने आप 2017 का लक्ष्य है ना, 2017 is the target. Then take the initiative yourself also. These questions have come in examination. And think before you answer. What will be the answer? All of them. Very good. किसने बोला all of them? हाँ जी? Bicameral legislature. नहीं, tell me the answer. Second and fourth भी. Somebody said third. Bicameral legislature is available in Britain. ये कैसा yes? Yes. Okay. Bicameral legislature is there also. Means they have a lower house and upper house at the union level. Lower house is called as House of Commons. Upper house is called as House of Lords. Very good. However, see, this is what happens when you read too much. In some other batch, somebody told me, sir, even this is a difference. And he had a point. Can you guess why he said bicameral legislature is also kind of difference? Yes, very good, sir. Because the upper house of Indian bicameral legislature, which is Lok Sabha, is a body of representation of states. By Rajya Sabha is formed to give representation to different states. How I'll tell when I take Rajya Sabha, though I have discussed that briefly. In Britain, the upper house is not formed to give representation to states. In Britain, upper house is formed to give representation to experience. There are people who are coming from different walks of life and they are experienced. House of Lords bolte hain usko. Okay, but then he's not asking about that. No, he's not talking about the upper house. He's talking about bicameral legislature. वो तो वहाँ भी है, यहाँ पे भी है. Sometimes this happens. This is same. I am warning you. It happens when you have studied too much. Then sometimes you apply that knowledge also, even if he's not indicating that thing. ठीक है? So read the question very much carefully. ये मेरा point है बताने का. Somebody from that side should answer. Question पढ़ लो. Is it visible from that side? Visible है. Give me the answer. Give wrong answer, no problem. बताओ सर, आप बताओ. Executive powers of the Union of India is vested in the Prime Minister. Yes के no? Yes है? It is vested in? I did not expect this answer from some people, but then this is the answer they are giving. COM कहाँ लिखा है? This is vested in President. Article 53 क्या बोलता है? Yes, the executive powers of the Union of India is vested in the President. That is a different thing. that those executive powers are actually just formally done by him or exercised by him. Support उसको किसकी लेनी पड़ती है? Prime Minister की. Getting this or not? देखो, you have to decipher the question carefully. He is not asking who is having the real executive powers. He is asking a simple thing. The executive powers of the union is vested in Prime Minister. गलत है ये, because it is vested in President as per Article 53. Real word use नहीं किया sir. Getting this or not? Now let's continue with our journey with articles. Where did we stop yesterday? Article 20 clause 2. You were there in na class yesterday? 20 clause 2 बताओ क्या चीज़ है? बिना पढ़े बताओ सर. Double jeopardy. यहीं से आपको याद हो जाएगा. Double jeopardy. Nobody can be punished more than once in a court of law for the same crime. अलग अलग क्राइम करो तो मिलेगी दो पनिशमेंट. 23 क्या है? याद रखने के लिए एनडी तिवारी जी. ओके. 20 clause 1 ex post facto. You cannot apply a criminal legislation, a criminal law retrospectively. Okay, you cannot punish somebody who committed a crime which was not a crime at that point of time, but it is right now. ठीक है sir? Now moving forward, let's take up Article 21, very very important article. Which article? हाँ जी. (15(4) and 16(4). देखो, 15(4) says that state can make. You all listen. 15(4) क्या बोलता है? What is the language of 15(4)? 15(4) says that state can make special provisions for the advancement of backward classes. ठीक है ना? Socially and educationally backward classes. And now, is it at any point of time mentioning what will be those provisions? ये कहीं लिखा है उसमें? नहीं लिखा है. That provisions, tell me, if you are the Prime Minister of this country, by what means you will bring benefit to these backward communities? Reservation. Bus. What else? बोलो. So, बिल्कुल सही कहा आपने. Reservation, but you say reservation in jobs दूंगी पहले तो मैं उनको. Then you also say I will give them reservation in education. Then you say I will waive off the fees for them. ठीक है ना? Then you can say that I will allow them to have a right to approach the higher educational institutions also with the support of state, of course. ठीक है ना? I mean, these are the special provisions. Detail वो है 16(4) में. 15(4) is a general thing कि हम इनका भला करेंगे, मगर भला कैसे करेंगे? वो कहाँ लिखा है? 16 clause 4 and other. For example, 16 clause 4A, that in promotion also we will give benefit to them. है कि नहीं है? These are the specific ways, provisions by which you will bring benefit to the backward. Getting this or not, sir? हाँ जी. Which schemes? DBT? Direct benefit transfer. हाँ. Is direct benefit transfer given only to SC STs? नहीं ना? वो poor के लिए. That is being given because of DPSP. DPSP में हम करेंगे. Okay? वहाँ SC ST का कोई लेना देना नहीं है DBT से. Next, Article 20 clause 1. Which article is called as the backbone of Part 3 and Part 4? Sir, what is Part 3 of the Constitution? Fundamental. And Part 4? Directive principle of state policy. Now see, Article 21 is called as the backbone of Part 3 and Part 4. You agree with this or not? You can disagree. But then, do you agree with this? बैकबोन तो है ही. नो नहीं सर, यस. सी, पार्ट 3 एंड पार्ट 4 क्या है? What is the ultimate purpose of part 3 and part 4? Part 3, 4 you know or not, sir? DPSP. DPSP means Directive Principles of State Policy. These are some directions or guidelines to the state. Listen very carefully. Part 4 में DPSP है. Directive Principles of State Policies are the directions or guidance given by the Constitution to the state that if you have to manage this country, you should manage this way, this way, this way. Bring relief to poor people. Prevent the slaughter of cow and other milch animals. Bring a green environment. Provide free legal aid to poor people. Okay. Ensure uniform civil code. इस तरह से आप गवर्नेंस करो. ये सारी चीजें कहाँ लिखी हैं? In DPSP. So if you see, the purpose of part 3 and part 4 is one only. क्या purpose है उसका? बोलो. Yes, to provide a dignified and a righteous way of living to everybody. सबको, भाई, why we are bringing uniform civil code? That day I told you what is uniform civil code. Uniform civil code is being brought so that the exploitation, particularly of women, is prevented, which is taking rampantly in few specific. ठीक है ना? So the purpose is to prevent their exploitation so that they can live a dignified life. और यही purpose है part 3 का भी. When I am giving you some rights, the purpose is you can live freely. You can live without fear. You can have a dignity. State should not come and crush you at any point of time. Even an individual cannot hurt your ego at any point of time. जैसे untouchability, वो ban कर दिया उन्होंने. तो यही purpose है. Part 3 and part 4, the purpose is to provide you not a life, but a dignified life. और वही article 21 भी है. If you remove article 21, the purpose of part 3 and part 4 is lost. फिर बेकार है ये part 3, part 4 बनाना. Write down. Article 21, right to life, considered the backbone of part 3 and part 4. It guarantees Sir, right to life is given to citizens or foreigners also? Both. ऐसा थोड़ी ना, it is not possible that if a foreigner comes here, we'll catch him. अब तुम्हारी जान हमारे हाथ में है. No. We have to respect even their life. Okay? Right now. Guarantees all the individuals right to life and personal liberty. आज़ादी भी होनी चाहिए. Right to life and personal liberty. Article 21, please keep reading whatever you are writing. Take an edge every day. Every bit of your effort at this point of time of your preparation will get reflected in your results. Believe me. What generally people do, they come to class, evening they feel tired, they sleep. ठीक है यार, कर लूंगा, आज मैं पढ़ के तो आ गया और वीडियो भी है, मैं देख लूंगा. You will never get a day when you will be able to watch the videos also, believe me. If you are not able to maintain pace right now, very difficult to maintain later on. And the day, every day you will be keep lagging. And after a month or 2 or 3 months, you will give up the hope also. छोड़ यार, अब इतना हो गया, अब मैं कैसे कर पाऊंगा. So do not lag behind. Every day you read what is being done in the class and come prepared little bit for the topic which is being taken up next class. तभी तो आपको बताते हैं what is the timetable. Take an edge. हर दिन एक edge लो दूसरों से. This is a very tough competition. I do not say that civil services is very difficult because of its content. It is difficult because of the competition level. 6 lakh people are appearing for it, and the duration of preparation, where you have to ensure your motivation level all through. Preparing for 1 month, 1 week is very easy. Preparing for 1 year becomes difficult. And particularly when you start lagging, when you see that this much has been covered and I have not revised even 1 page, the motivation will go that day itself. And do not rely on the fact that I am coming from IIT or I am coming from IIM. I just do anything which I feel like. Or you do not get an inferiority complex also, that I am coming from D grade college or E grade college. No matter from which college you are coming, your sincerity at this stage of life will define your future life. ठीक है सर? Write down. Article 21 has emerged as fundamental of all the fundamental rights, and has been interpreted in most extensive manner. That is most evolved, evolution से evolved बना है, most evolved article, which has given rise to largest number of inferred rights, inference से बना है, inferred rights or derived rights, means the rights which were not explicitly mentioned in the constitution, but they have now been declared a right by whom? Supreme Court. ये right कहीं लिखा हुआ नहीं था, मगर Supreme Court ने माना that since you have right to life, you also have this right. For example, right to privacy. Nowhere in the constitution it is written that you have got right to privacy. But in one of the cases, Supreme Court declared that since you have a right to life, that cannot be achieved without having privacy. So you also have a right to privacy as your fundamental right. Though we do not call them as fundamental right, we call them as derived fundamental right or inferred fundamental right. ठीक है ना? Getting this or not? Now, you agree with this or not, sir? Privacy के बिना तो कुछ हो ही नहीं सकता. Will you ever feel secured if your privacy is compromised? No. Another example, right to chalo health, then right to clean environment, right to corruption free administration. If there is corruption, then if there is rampant corruption which is prohibiting your growth, then you can approach Supreme Court also, citing that your right to life is getting jeopardized because of huge corruption in administration. Supreme Court may entertain that plea. ठीक है ना? Or for example, right to shelter. This is also kind of derived fundamental right. If you know this thing, when the cold comes, जब ठंड आती है, in that case, when it is cold, in that case, many people die out of cold. Then Supreme Court and even High Courts, they keep giving tough directions to the state that why are you not providing them shelter? The people are dying. Not just because they feel like doing humane to something to them. It's because right to shelter has been declared by Supreme Court as a part of right to life. और बात सच भी है. एक आप देख लो, just for example, right, one or two rights. For example, largest number of inferred rights. For example, largest number of inferred rights. For example, right to privacy. Is right to primary education also a kind of fundamental right? Elementary, up to explicitly they have formed it, but that was formed in 2002. Now you have right to elementary education as explicit fundamental right under Article 21A. But in 1992, I mean 10 years before you actually got it made a fundamental right, 1992 itself, Supreme Court said people or children, they have this right to primary education. And therefore it was declared a kind of fundamental right. And after 10 years, Supreme Court passed the law specifically that from now on, elementary education, though they did not say elementary education, 6 to 14 years of age, right now, right to primary education, right to speedy and fair trial, right to speedy तेज, speedy and fair trial, right to health of workers, one of the right is in news, this right अभी news में चल रहा है, for what reasons? सर आप पेपर पढ़ते हो नहीं पढ़ते हो? बताओ जल्दी से. You tell me, sir, why this article 21 is in news right now? Front page पे आ रहा है यार, you cannot miss that. Right to shelter, right to corruption-free administration, right to clean environment, right against cruel punishment. Article 21, keep reading what you're writing. Article 21 as per Supreme Court के हिसाब से, Article 21 as per Supreme Court does not merely provide right to life, but right to life नहीं है तो क्या है? Very good. Right to dignified life. You need to have a life of human, not like. Very good, sir. Therefore, it could be seen that all other fundamental rights and DPSPs ultimately aim to extend this quality of life to people without Article 21, all other fundamental rights will become meaningless. बहुत बढ़िया. Will become meaningless. At least everybody is attentive. Article 21 brings out, write down, Article 21 brings out the difference between a police state and a constitutional state. Police state and a constitutional state. You agree with this or not? By police state is one where you have no rights. You can be tortured at any point of time, or state will treat you arbitrarily. But then Article 21 will prevent the state from doing this or not? State is bringing the maximum pollution here. Your right to life violated or not? You will go to court. But then had it been a police state, they would have been polluting and then nobody would have listened to you also. But thankfully we have Article 21, so people can listen to you, courts are there to listen to you. समझ रहे हो सर? Otherwise, Indian state can become a police state. Very, very interesting topic. हाँ सर बोलो. Death punishment Article 21 को violate नहीं करेगा. Am I audible? Death punishment will not violate Article 21. And Article 21, अच्छा, death punishment, why should it violate Article 21? Tell me. Why do you feel even that way? Right to life है. But then एक बात बताओ, did I not tell you that only Article 17 is absolute? कोई और आर्टिकल ऐसा नहीं है where there is no asterisk mark below it. सब जगह एक तारा बना हुआ था ना, condition applies. Your right to life is there, provided you also remain within the limits. I told you when I was taking constitutionalism, when there is constitutionalism, not only limits are put on state, limits are also put on people, state, citizens. You cannot take this as an immunity. समझ रहे हो सर? इसका आंसर करो. What is procedure established by law? What is procedure established by law? हाँ जी. बोलो बोलो बोलो. And that has to be followed. है ना? Very good, sir. And this concept has been taken from which country? UK. See, for the people who do not know, be very attentive, and this is very important and interesting article also. Procedures established by law, do not write, just listen. पहले समझो इस बात को. This concept has been taken from UK. होता क्या है? Take this case. Parliament made a law. Parliament ने कानून बनाया that from today itself, if somebody is found smuggling cattle मतलब गाय भैंस and all these things, okay? If anybody is found smuggling cattle, then any group, vigilante group, कोई भी group, नाम कुछ भी दे दो, गौ रक्षक दल और ऊंट रक्षक दल, whatever, ठीक है? They can stop the smuggling, plus they can publicly beat or flog the person who is caught and keep them in detention till the time it is required. And not only this, this power is given to police also. एक लॉ बन गया that from now on, if somebody is caught smuggling cattle, in that case, police can stop the van, bring the person who is driving the van, beat him publicly, and if required, that fellow can be detained till the time it is the pleasure of police. पुलिस को जब तक अच्छा लगेगा उनको अपने पास रखेंगे. Now this is a law, and this law is presumptively formed by Parliament. ये सिर्फ एक hypothetical case है to explain you the concept. This is law made by Parliament. Now, is there any problem with Parliament making a law? By Parliament का तो यही काम ही है. Parliament made the law and Parliament passed it with proper procedure also. जितने भी procedure हैं वो follow करके law बनाया गया है. Parliament passed a law following all the right procedures. Understood? In that case, one case happened where somebody was caught smuggling cattle. पुलिस ने उसको उतारा. And he was beaten so badly that he was just near to his death. ठीक है सर? Means threat came on his right to life. भाई उस स्मगलर की इतनी पिटाई हुई कि वो मरने ही वाला था. And his right to life got endangered or not? Article 21 में. Now, after recovering, ठीक होने के बाद, he filed a case in Supreme Court. उसने केस किया Supreme Court में. Why I was beaten so much by police? I was about to die. Then Supreme Court opened the books and they said, my dear, see, police did not act arbitrarily because as per the law, police had this power. And the law when it was formed by Parliament. जिसका काम ही law बनाना है. Moreover, when the law was made by Parliament, every procedure was correctly followed also. तरीके से कानून भी पास हुआ है. So there is no reason we should invalidate the action of police. इसको कहते हैं, this approach of reviewing the action of executive is called as procedure established by law. दोबारा सुनो. Procedure established by law is an approach of judicial review in which judiciary will see that whether the action of executive are based on a law which is passed by a competent body as per the proper procedure. If that is the case, then judiciary will not nullify or take action against the executive. एग्जीक्यूटिव ने जो भी किया, भाई पुलिस इज पार्ट ऑफ एग्जीक्यूटिव और नॉट, इंप्लीमेंटिंग बॉडी तो है वो. वट एवर पुलिस डिड वॉज एज पर द लॉ, एंड दैट लॉ वॉज फॉर्म्ड बाई द कॉम्पिटेंट बॉडी पार्लियामेंट, एंड व्हेन पार्लियामेंट मेड द लॉ, प्रोसीजर्स वर आल्सो फॉलोड. सो इन नो केस जुडिशरी विल से दैट रॉन्ग हैपेंड. क्यों? बिकॉज जुडिशरी वॉज फॉलोइंग प्रोसीजर स्टैब्लिश्ड बाय लॉ. ये एक अप्रोच है. प्रोसीजर established by law is an approach of judicial review. ये चीज तो ये थी. But once happened in 1978, there was a famous case which was called as Menaka Gandhi case. Menaka Gandhi case 1971. Do not write. I'll dictate, don't worry. Let's focus here. इन मेनका गांधी केस सुप्रीम कोर्ट को एक इंसाइट मिली. सर एक बात बताओ, डू यू एग्री विद दिस अप्रोच? व्हाई नॉट? नहीं, प्रोसीजर्स वर राइट. प्रोसीजर्स में गड़बड़ी नहीं थी एंड दे वर फॉलोड आल्सो. यू टेल मी, डू यू एग्री विद दिस लॉ? अरे आप मुझे वो छोड़ो, ये बताओ, यू आर अ जज, डू यू जस्टिफाई द लॉ? देखो कितना सोचने का टाइम लगा रहे हो. चाइना से आए हो क्या? जल्दी बताओ. एज पर इंडियन स्टैंडर्ड्स, डू यू एग्री विद दिस? नो. आप एग्री तो नहीं करोगे ना सर, बिकॉज यू विल फील दैट देयर इज अ प्रॉब्लम. यू विल फील दैट देयर इज अ प्रॉब्लम विद दिस लॉ. रीजन इज दैट देयर इज ऑलवेज अ स्कोप ऑफ. इस लॉ के अंदर एक स्कोप है कि नहीं है? किसका है? There is a scope of arbitrariness in this law. Police can at any point of time collect anyone, beat them, and that too without giving any justification. Understanding or not? So, under, एक बार let me repeat once again, it is a very important concept and be very attentive if you have missed that. Under procedures established by law, judiciary will see whether a law which according to many people is very tough law, very wrong law, and executive is using that law to harass people. पुलिस उसका मिसयूज भी कर रही है परेशान करने के लिए लोगों को. If the judiciary is following this approach, which is called as procedure established by law, in that case, judiciary will see only two things. कि ये law which is being misused or used by executive, was it made by a competent body? Or was it made after following proper procedures or not? Khatam. If these two standards are met, then that law is right. तो वो कानून सही है and its implementation is also right. If police is doing so, it is doing so because there is a law and this is right. फिर judicial intervene नहीं करेगा. And this was a practice till 1978. Thankfully, in 1978 there came a famous case called as Menaka Gandhi case. अब इस केस में क्या हुआ? In Menaka Gandhi case, Supreme Court said that in future, and in this case also, any issue relating to right to life will be judged with a different approach, not according to the procedure established by law, but it will be used using different approach, and that approach is called as due process of law. अब ड्यू प्रोसेस ऑफ लॉ क्या है? अप्रोच दो है. आई एम जुडिशरी, आई हैव टू सी वेदर द एक्शन ऑफ एग्जीक्यूटिव, लेट्स से पुलिस और मिलिट्री, वेदर देयर एक्शन इज राइट और रॉन्ग, मुझे ये जज करना है. आई कैन यूज टू अप्रोचेस. वन इज प्रोसीजर एस्टैब्लिश्ड बाय लॉ एंड द अदर अप्रोच इज ड्यू प्रोसेस ऑफ लॉ. If judiciary is following the approach of procedure established by law, it will not see whether that law is just, fair or inhumane. वो इन सब में नहीं पड़ेगा. Judiciary will only see whether there is actually a law which is authorizing the executive to do this to people, and whether that law was made following proper procedures or not. बस judiciary इतना देखेगा. If these two conditions are met, then action of executive towards people will be justified. ठीक है, वहां रोकेगा नहीं. But 78 judiciary said no, this approach is very mechanical. अगर यही करना है, this work can be done by computer also, right or wrong? Why for there is judiciary? Why we put people in the seat of judges? Because judges can see something which machines cannot see, the spirit of humanity. The due process of law, Supreme Court said, now on we will not follow procedures established by law as an approach to review the action of executive, but we will use the approach of due process of law, in which we will see three things. Is there a law which is allowing an executive body to do this? Secondly, was that law made using proper procedures? And third, is this law humane? Is this law just? ये सही भी है कि नहीं है? In spirit. इसे कहते हैं due process of law. And now on, after 1978, Supreme Court is following, or even High Court, they are following due process of law regarding any case related to right to life. Understood? Understood or not? Which is more mechanical approach? Procedure established by law or due process of law? Procedure. क्योंकि when we have due process of law, judiciary will see the spirit behind a law. ASPA का ले लो, Armed Forces Special Power Act. Armed Forces Special Power Act. I am not saying it is right or wrong. Okay, I am saying that judiciary can say that ASPA is giving exclusive power to military people in disturbed areas, which is being misused also by them against these innocent civilians. So they can scrap it also. But the issue is that ASPA has negative points, but they also have positive points. To manage a chaos, I need to be tough also sometimes. और ASPA वहीं से justify हो जाता है. Getting this or not? अब ये अभी खत्म नहीं हुआ है. You write 2-3 lines, and when you write it, please keep reading, because now I'll take the discussion to the next level. Procedure established by law. The concept originated in England. The concept originated in England. Why do you feel that this originated only in England? Yes, very good, excellent. भाई ब्रिटेन में sovereign कौन है? Parliament. Every action committed by Parliament in Britain is actually supported by judiciary. They do not, बस वो ये देख लेंगे procedure पूरा है कि नहीं है. ठीक है, write down. Originated in England under this principle. When a person is deprived of, keep reading what you're writing, deprived of his life or liberty the court will examine whether there is actually a law, ऐसा कोई कानून है भी जिसको यूज करके इन्होंने ऐसा किया. Actually there is a law that authorizes the executive to deprive the individual of his life and liberty further. The court will see whether that law was passed by a competent law making body. जिस बॉडी ने लॉ बनाया उसके पास पावर भी थी लॉ मेकिंग की कि नहीं, and whether proper procedures were followed while passing the law. The court, however, the court, however, will not see or will not examine better, will not examine what? Very good. Will not examine the fairness of the law or the motive behind the law. Was the motive to harass people or what? Or the motive behind the law, and cannot declare a law unconstitutional and void therefore this doctrine means principle, therefore this doctrine of procedure established by law, short form use कर लो PEBL, this doctrine of procedure established by law relies means depends, relies more on नहीं लिखना, more on, okay, it relies more on the good sense means faith, good sense of legislature or executive, legislature, good sense of legislature and strength of public opinion, means the judiciary will presume that legislature will not do anything wrong, वो कानून गलत नहीं बनाएगा, okay, and strength of public opinion in the country means even if they want to make any wrong law, but people will stop them. This is a presumption of judiciary, so why should I bother myself for this thing, okay. It extends, last line, it extends the protection to an individual against the arbitrary action of legislature, executive, both or none. Very good. Executive. Against the arbitrary action of executive only. Because it is depending on legislature good sense. कि भाई वो तो जो करेंगे सही करेंगे. Somebody who can actually not implement it well is executive. But not that of legislature. Now continue from here and give a next heading, due process of law. Due process of law. The concept originated in, very good, USA. Of course, USA. The concept originated in USA, conferring greater powers on judiciary, Please read what you're writing, though I've explained it, but then still read it. Under this doctrine, the courts, while examining a law, will not only look at the law from the point of view of competence. Competence means authority. क्या authority थी उसके पास जिसने law pass किया? From point of view of competence of the legislature. that passed the law, and also that whether the law followed the proper procedures, whether the legislature followed the proper procedures, while passing the law, but will also see what? Very good. But will also see whether the law is just, and fair or not. Whether the law is just and fair or not, by applying the principles of what? Very good. By applying the principles of natural justice. I'll tell you what is natural justice. Give the heading Principles of Natural Justice. There are three principles which together form something called as principle of natural justice. First principle, Hanji.
I don't know the number, but I can say all the all-time parties, both parties have to be heard. Nobody can be a judge in his own case. The judges have to give a reasoned decision.
Excellent. इसको सिंप्लीफाई और हिंदी में लिख देता हूं. ओके, nobody can be punished unheard. Okay, if I have to punish somebody, I should give him a fair chance to put his point, or at least I should tell him why I am punishing him so that I can put his point also. Okay, then nobody can be judge of his own case. अपने ही केस का जज खुद बनोगे तो क्या करोगे? Simple as that. There is a case or a dispute in which you are involved, sir. What will you do? You will favor yourself. अपने खिलाफ ना judgment दोगे. You will favor yourself. So it is also against principle of natural justice. Third thing is that authorities must act bona fide. Bona fide means with good intentions. Intention सही होनी चाहिए. And act without bias. ये भी लिख लो. And act without bias. These three principles together are called as principles of natural justice. I'll give you a very beautiful case study to tell you how in one case somebody violated all these three principles. And it is a kind of lesson for all of us, and particularly you people, that once you clear civil services, never violate these principles, because then you might have the power to do this. ठीक है sir? See this. No, I will not mention the name of this officer, though I know him or her very closely. See, lady officer, IAS officer, freshly into the service. When you become part of the service, you join as SDM or DM सीधा? SDM. She became SDM of a particular city, Chandigarh city. Okay, वहाँ की SDM बनी वो South Chandigarh. Then she was moving. This came in newspaper, so I am telling you the report. Okay, I'm not saying whether she actually did this or not, but then the actions appear to be violation of principle of natural justice. Okay, she was moving very fast. Of course, the car was not driven by herself. The driver was driving the car, and she had to greet the President of India that point of time, Abdul Kalam. Driving the car at a fast speed, somebody came from that lane, opposite lane. एक यूं जा रहा है, एक ऐसे आ रहा है, right? It happened so. She overtook the car in front of her. मतलब उनके ड्राइवर ने overtook किया अपनी कार को, आगे वाली गाड़ी को. And when he overtook the car, he entered into the wrong lane. दूसरी lane में चले गए. The person was coming from that side also. I mean, he should have actually given way. चलो, that car is coming, I should give way. Of course, there is a light also on that. So, रास्ता देना चाहिए कि नहीं देना चाहिए? देना चाहिए. Where it is written that if there is a लाल बत्ती car coming in a wrong lane, you have to give way. ये तो कहीं लिखा नहीं है ना. To teach her a lesson, because see, sometimes it is the abuse of power also, which make these people do this. They drive in the wrong lane, jeopardizing the life of other party also. The other fellow, he did not give way. वो अपनी लेन में जा रहा था, and he put a brake. Okay, ऐसा नहीं कि वो चलता चला गया, I'll suicide bomber बन के. No, he put a brake. उसने ब्रेक लगा दी. Other party also was forced to put a brake, but brake तो लग गई. That time nothing happened. Okay, they went. In the evening, when this fellow came back home, he was a businessman, young businessman. He came home after having snacks at 7 o'clock. It was Friday evening. Two policemen came and told him, चलो चलना है. He said, कहाँ? अभी बताएंगे, जेल चलना है अभी तो फिलहाल. He was taken to custody. 7 o'clock Friday evening. Saturday, Sunday court खुलता है? No. He was taken and put behind the bars, and actually no reason was also given to him. Those constables, they told him that you were involved in road rage. हमें complaint मिली है. अरे complaint किसने लिखाई है? पता नहीं. You were involved in road rage. Anyways, next day he came to know that the complaint was actually filed by the same SDM. तब तो उन्होंने कुछ नहीं बोला, चुपचाप नंबर नोट कर लिया था उसका, because she had to receive the president also. चली गई. This fellow was actually not given any chance to put his case, and he was put behind the bar. On Monday, after spending 2 days and 2 nights in jail, on Monday he was brought in the court of executive magistrate. Magistrate, I mean, when you join as SDM, you do some functions as magistrate also, executive magistrate. Then he was brought to the court of the magistrate. You know in which court was he called? The same lady. उन्हीं के court में बुलाया गया उनको. Then this lady, she pronounced a punishment to this fellow, that you were engaged in a road rage case and the other party was my driver. इसी के साथ तुम road rage में engaged थे, तुमने उसको पीटा, और now I punish you with this much of sentence. That fellow must have also attended coaching somewhere. उनको ये पता था ये कुछ है natural justice. He told her, madam, first of all, I was caught and they did not even tell me what was my fault. Forcibly I was put into the jail. उसके बाद, now you are asking me to come in a court of yours only, and you are a interested party in this case. So are you not becoming judge of your own case? She said, मैंने भी किया था course and I also have read. Counter चल रहा है दोनों party. She said, see, this case is actually not related to me. This case is filed not by me. This case is filed by my driver. समझ रहे हो? Driver ने case file किया, मैंने थोड़ी ना किया. I am only a judge. Then other party, he had read these notes along with Lakshmikant. उसने बोला, madam, even if this is your driver's case, you are indirectly interested or beneficial in this case, so you cannot actually become a judge in this particular issue. आपने तो पहले natural justice का violation कर दिया. Understand? And later on, even a minister, he gave this kind of comment that this action of this lady, SDM, is violation of principle of natural justice, and this fellow, I mean, she did not actually act bona fide. An action should be taken against her. ठीक है ना? Later she backtracked also, compromise वगैरह हो गया उनका. But then what I wanted to convey was that in this one story, you see 3 things happening. That fellow was punished. He spent 2 nights without any reason, बिना reason के. Then also she became judge of her own case, violation of principle of natural justice again. Third, Mona, she actually act biased in the favor of her driver. तो ये violation है कि नहीं natural justice का? Now when this case comes to judiciary, judiciary के पास मान लीजिए ये same case आता, the same case actually went to judiciary, high court में उन्होंने case कर दिया था. Now this case is coming to High Court. Sir, आप बताओ, what will you say? Will you condone the action of the executive? Executive means in this case SDM. आप माफ कर दोगे उनकी एक्शन को? No. Had he been following, देखो आप ध्यान से सुनो, had he been following the procedure established by law, he would have condoned her action. क्योंकि उनको माफ क्यों किया होता? Because she had this power to call somebody to court. वो तो power थी उनकी. Police had the power to arrest somebody. Okay, and there was no way we could actually prove that she was not acting bona fide. Under procedure established by law, judiciary would have seen only this thing: is there a law by which police can arrest somebody who is involved in a road rage case, right or wrong? And yes, बिल्कुल. और 24 घंटे के अंदर मजिस्ट्रेट के सामने भी इनको लाना था, but then Saturday Sunday are excluded in that. ठीक है ना? So as per the law, what was being done was right, but then don't you see that the intention behind this action was wrong? So it was violation of principle of natural justice. अब judiciary बोलेगा release him because you have violated principle of natural justice. मगर had judiciary been following procedure established by law, it would not have actually gone into these nitty-gritties. Now see, write down. Due process of law originated in in USA. This is done, na? Due process of law extends the protection to an individual against the arbitrary action of executive. वो तो ड्यू प्रोसेस ऑफ लॉ में था. आप ये देखो, this provides protection against the action of executive. ठीक है? It will, here judiciary will only see whether there is a law or procedures were followed rightly or not while implementing that law, while making the law. ठीक है? वो बस इतना देखेगा. Whether that law is right, wrong, fair, unfair, that will not be seen by judiciary. मतलब judiciary is not actually going in depth against the action of legislature. वो नहीं देख रहे. However, if that law is also not implemented well, उस law को भी तोड़ मरोड़ के उन्होंने use किया है, then action of executive will be cancelled. तो action of executive is questioned or not under this procedure. Due process of law, here judiciary in a particular case relating to right to life will not only see whether there is an action by which somebody's right to life can be threatened, it will also see whether that law is itself fair or not. I gave you the example of Armed Forces Special Power Act. If Armed Forces Special Power Act, any case goes to judiciary, for example, a village was burnt alive. The whole village was burnt alive by armed forces, allegedly by armed forces. ठीक है ना? That case went to judiciary. In this case, judiciary will see that first this action was committed by the armed forces people using the immunity under Armed Forces Special Power Act. But then अब वो ये बोल देंगे इस केस के अंदर Armed Forces Special Power Act itself is faulty because it actually violates the right to life of people and it gives arbitrary powers to executive. What I mean to say is that judiciary can say so, but judiciary is not saying so, reason being the larger purpose of AFSPA is much more than this thing. अभी तक उनका perspective ये है कि AFSPA is justified provided there should be limit on its use. Due process of law, the judiciary is actually putting fingers against the action of executive as well as legislature. वो ये बोल देगा that ये law ही गलत है. Judiciary will say that this law itself is faulty, which you have made, and it can also ask the executive, the way you are implementing that law is also wrong. मतलब action दोनों के against हुआ ना, executive as well as legislature. I gave an example that tomorrow there can be a law by which anybody, police can stop a van carrying cattle और उसको publicly मारेंगे. In that case, action will also be taken against legislature कि आपने एक कानून ही गलत बनाया. You made a faulty law. You made a law which is arbitrary. You made a law which give excessive power to police. Understanding or not? So in this case, because judiciary is using due process of law, it is going into the spirit of the law also and declaring a law itself wrong because of its intention, not because of the procedures followed while making the law. Because that law was violating the principle of natural justice. Let me further simplify this by an equation. Cognitive means something related to thinking. Under article U oblique A matlab it is not the censor certification, it is under article 21. Clear to all? And the doubts whatever you will have, that will be clear once you read it again at home. जो बचा कुचा doubt है वो घर पे खत्म हो जाएगा. If you want to ask anything, you can ask right now also, no problem with that. Due process of law extends protection against the action of executive or legislature? Both. Write down, under our constitution, our constitution under article 21, our constitution under article 21, Our constitution under article 21 has provided, constitution में तो सिर्फ procedure ही दिया हुआ है. Our constitution under article 21 has provided only for procedures established by law, but Supreme Court in Menaka Gandhi case 1978 interpreted article 21 to include the doctrine of due process of law under article 21. To include the doctrine of due process of law under article 21 by reading मतलब पढ़ना, by reading or including actually, by reading the incorporation of principles of natural justice in article 21. Principle of natural justice. Did you write the 3 points? सब लोगों ने लिखे ना? Principle of natural justice, let me repeat, these principles are, इसको भी लिख लो. These principles, principle of natural justice, give this heading, principle of natural justice, PONJ, are regarded as universal in character, तीन प्रिंसिपल है नेचुरल जस्टिस के. नोबडी शुड बी पनिश्ड अनहर्ड, बिना बात सुने किसी को पनिशमेंट मत दो. देन अथॉरिटीज शुड एक्ट बोनाफाइड इन गुड इंटेंशन. एंड सेकंड वाज नो वन कैन बी द जज ऑफ हिज ओन केस. ये तीन प्रिंसिपल फॉलो करने हैं आपको. ओके, एंड व्हाई इट इज सेड दैट दे आर यूनिवर्सल? एनीबडी? दे आर यूनिवर्सल बिकॉज दीज प्रिंसिपल्स, देखो, principles of natural justice abhi aapne likha hai, they are called universal. Universal means there is no organ of the state which can violate these principles. Legislature cannot violate them. Legislature cannot make a law which actually violate them. Legislature, law making body, parliament cannot make a law which says you punish somebody even without hearing him. aisa kanun ban hi nahi sakta. And if tomorrow legislature makes a law, that will be nullified by judiciary, because it is a violation of a principle of natural justice. Parliament cannot make such a law. Executive cannot act in a way जैसे उस SDM ने किया, because that was also a violation of principle of natural justice. Judiciary can also not violate principle of natural justice. If I have, for example, if my relative has a issue going on, then that case cannot come in my court. You know this or not? I cannot be a party to a case in which I have direct or indirect interest. मतलब even judiciary cannot violate principle of natural justice. क्योंकि अगर मैं अपने रिश्तेदारों का केस लड़ूंगा, will I not make them win? Unless I have a grudge against them. वो भी गलत है. That is also a violation of natural justice or not? भाई किसी रिश्तेदार से बड़ी दुश्मनी थी. 3 times I appeared in mains and 3 times he was the first person to ask the result. बताओ. अब मेरी बारी है. That is also wrong. Whether I favor somebody in his way or I become prejudiced against him, both is violation of principle of natural justice. So universal hai, they are applicable on executive, legislature, judiciary or any organ of the state. ठीक है? हाँ जी सर. Till 1978 we were following this. Article 21 only. If Article 21 there is a law which is made which is violating your fundamental right, fundamental right नहीं, सिर्फ Article 21, and executive has done so. ये लेजिस्लेचर के अगेंस्ट नहीं है यार. दिस इज व्हाट आई एम टेलिंग यू अगेन एंड अगेन. दिस इज एप्लीकेबल अगेंस्ट द एक्शन ऑफ एग्जीक्यूटिव. Was Article 13 aimed against executive? That was aimed against legislature. So you actually got double protection or not? If legislature makes a law which takes away a fundamental right, protection will come through Article 13. If executive actually carries out an action which was wrong, protection can become through this due process of law. Difference है कि नहीं है? अरे उनकी बात भी सुनो. He is putting a valid question. हाँ जी सर. Yes. What else? Judiciary there is considered to be highly organic. Yes. अरे हम अमेरिका से पीछे थोड़ी ना. Our judiciary also is not very far from America. In fact, now our judiciary is becoming much more vigilant than even their judiciary. Getting this or not? Nowhere in the constitution it was written that judiciary can use due process of law. ये तो कहीं लिखा नहीं था. But judiciary itself took this power on itself so that its judgment can become humane. It can become a better protector of fundamental rights. It can become a better protector of constitution. And it can ensure separation of power. It can ensure limited government. It can ensure constitutionalism. So much so has happened really after 1970s. Concept of basic structure came in 1973. Then what else will be part of basic structure came on with subsequent pronouncement. For example, judicial review is part of basic structure 1980 Minerva Mill case. So ये देखो, this kind of vigilantism in the action of judiciary came with after 1970s. उससे पहले, before that, judiciary was not very much known for being very active or very organic. After that, judiciary became famous to be organic. Now, don't you have much trust on judiciary than what actually you have on legislature and executive? Really, मैं बताऊं. Though it is not to be written, but then still this is the kind of feeling. Reason being, you know that even if something is not written in the constitution, judiciary will bring it in the larger interest of nation and the constitution. PIL, public interest litigation. You know this or not? Public interest litigation क्या चीज़ है? Public interest litigation means if something relates to larger public, you are seeing as a violation of some rights or something wrong in the system, then you can write to judiciary. Sir, please come and help us and give justice because the larger section of society is getting influenced by this action. So वो PIL है. Nowhere in the constitution it was written that judiciary will have this power to entertain PIL, but judiciary invented this thing. I'll tell you when I take PIL. PIL, just a simple prisoner in Tihar jail, he write a simple letter to the judge of Supreme Court. Sir, we are being mistreated this way. एक simple letter लिख दिया उन्होंने. And Supreme Court was so innovative, so organic. They said, consider this letter. और scribbled, it was not even written in good handwriting. फटा हुआ letter था. Consider this letter as a PIL, as a litigation. And here started the concept of PIL. तो अमेरिका से बहुत कम नहीं है सर हम लोग. Though that is inspired by American actions only, because PIL is also coming from social action litigation concept, which is present in America or which was present in America right now. Since they are universal, they means principle of natural justice. Since they are universal, they are binding on. Since they are universal, they are binding on all the authorities. प्री में क्वेश्चन बना देंगे वो किसी भी तरह से. They can put a question: is principle of natural justice applicable on executive, legislature, judiciary, all of them, none of them, or combination? They are binding on all the authorities, including judiciary, legislature, and executive. But will it actually apply on private individual also? Apply होगा सर आपके हिसाब से? Yes, very good. And even on private individual, I cannot punish somebody without giving him proper justification time. And all the organizations. The purpose of these principles is to exclude, the purpose of these principles is to exclude the chances of arbitrariness in decision making and humanizing the decision making since they emphasize that actions must be supported by reason, that actions must be supported by reasons. Supreme Court held that these principles, means principle of natural justice, Supreme Court held that these principles are found in Article 14 and 21 implicitly. They are so important for the functioning of state that they can be regarded as part of basic structure of constitution. Which article we were doing right now? 21. Very good. After Article 21, this is the time of Article 21A. Write down. Article 21A, introduced by '86th Amendment Act 2002. Was 2002 the year when RTE Act was formed? When was it formed? 5 or 9? 9. देखो ये फर्क है, and let me tell you, because see, I have seen many people, many students getting confused over this. So I am telling you before you ask me this. This is an act. Amendment Act क्या एक law ही है. This is a law which gave power to Parliament that now you can make further law in the area of elementary education. You are empowered to make law for elementary education given free to children. 6 से 14 साल के बच्चों को आप free education दे सकते हो. This power came on Parliament through this act of Parliament itself. Constitution ने पहले Parliament को power दी that you can make law in this area. Then further Parliament will make law in that area. जैसे कि 86th Amendment Act 2002, it made right to education a fundamental right. Anybody who is from 6 to 14 years of age is having a fundamental right to get education. ठीक है सर, ये तो सिर्फ इतना है. But then देखो confusion कहाँ होगी? Then you will feel यार RTE Act, what was the need of bringing RTE Act? बताओ सर, what was the need of bringing RTE Act when this amendment was actually brought and it made fundamental right also, right to education? Implementation भी तो चाहिए ना. You made a resolution that I will clear civil services. वो तो सिर्फ एक resolution है ना. It is to be implemented also. Implementation कैसे होगी? By buying books, buying admission, and of course by studying also. Right or wrong? ये दो चीजें हैं. First, Parliament power लेती है through Constitution, and then further it will make law to implement that thing. ये है फर्क regarding the Act of 2002 and 2009. Right now, Article 21A introduced by 86th Amendment Act 2002. Keep reading what you're writing. Under this, state shall provide free and compulsory education. Have they used the word elementary education here? No. 6 to 14. I may be 14 years of age but still studying in class 2nd. ऐसा भी तो हो सकता है sir. Right down. State shall provide free and compulsory education for all children between the age 6 to 14 years as provided by law. बच्चों को फ्री एजुकेशन भी मिलेगी और कंपलसरी. सर हु विल प्रोवाइड फ्री एजुकेशन एज पर दिस एक्ट? स्टेट. फ्री एजुकेशन तो स्टेट दे सकता है. कैन स्टेट ऑल्सो गिव कंपलसरी एजुकेशन? नो. कौन देगा कंपलसरी एजुकेशन? पेरेंट्स. भाई स्कूल घर पे थोड़ी ना आएगा चलो तुम जबरदस्ती. नो. कंपलसरी एजुकेशन इज द ड्यूटी ऑफ पेरेंट्स और द गार्जियंस. Free education, providing free education to 6 to 14 years of age children is the duty of state, but providing compulsory education is the duty of parents or guardian. ठीक है ना? State cannot be questioned कि why these children are not coming to school. The best they can do is they can provide them free education along with some inducements, free khana, free books, free this, free that, free movies. ठीक है ना? That can be provided by state. But they cannot go into the homes of children and pull them out. Right now. It is a fundamental right of children between age 6 to 14 to get free education, which can be enforced upon the state, Compulsory education, full stop के बाद, after full stop, compulsory education will be the responsibility of parents which has to be provided by law. कानून में लिखेंगे कि ये कंपल्सरी एजुकेशन की ड्यूटी पेरेंट्स की है. The law will write this explicitly, which shall be provided by law, under which parents will be under duty to send their children of age 6 to 14 to school. Means we made a new fundamental duty for parents and guardians to send the children to school. Under which article? 51? A, K or both? Both. A, K. ठीक है? How many fundamental duties are there? 9, 10, 11, 12. 11. Write down. Article 51AK, when was it formed? With same amendment. Very good. 86 से ही बना ये. Okay, 86 Amendment Act also brought a new fundamental duty. ये भी आपने लिखा है. Article 51A(k) says that it is the duty of every citizen who is a parent or guardian to provide opportunity for education to his child between the age 6 to 14. Article 22 खत्म होने वाले हैं, only 10 remaining. Article 22. See, why should we be bothered? Ultimately, this is something which will get you through also. If by reading just one topic, fundamental rights, you can have access to 2-3 questions, what's wrong in that? है कि नहीं है? This is highly important. इसके बिना काम बनेगा नहीं. Understanding, sir? Do not develop preferences for subjects or topics, because whether you like it or not, you have to do that also. Instead, better है that the subjects which are more phobic to you, or the topics which are more uninteresting to you, you develop a liking for them. जो सबसे बुरी लगे उनको बोलो नहीं यार इससे अच्छा कोई है ही नहीं. That will make your sufferings come down. ठीक है? Article 22. Anyone, what is Article 22? हाँ जी, कैन स्टेट अरेस्ट यू? नहीं क्यों? यस, स्टेट आपको अरेस्ट कर सकता है और करते ही है वो. बट यू डू यू हैव अ फंडामेंटल राइट अगेंस्ट अरेस्ट? अभी तो बोला कि कर सकता है स्टेट आपको. यू डू नॉट हैव अ फंडामेंटल राइट अगेंस्ट अरेस्ट, बट यू हैव सम प्रोटेक्शंस व्हाइल यू आर बीइंग अरेस्टेड. अरेस्ट करने का भी तरीका है. स्टेट कैन नॉट अरेस्ट यू आर्बिट्ररीली. When state is arresting you, some steps are to be followed and some protections are to be extended to you, and those protections are mentioned in Article 22. याद रखना इस बात को. If the question comes, do you have a fundamental right against arrest? That answer is no. You don't have any fundamental right against arrest. But then during arrest, you have some protections. कुछ सहूलियतें मिलेंगी आपको. Then you can avail under Article 22. You have seen that in movies or not? When the police come to arrest a villain or the hero, चलो थाने चलना है. Then what is the word? I mean, he drops then. Warrant. हाँ, वो ये बोलेगा, do you have a warrant? Or then he will tell the policeman that wait for some time. Let me talk to my lawyer. ये बोलते हैं ना? And police allows that or not? Generally they allows, but then they can also say हाँ बात कर लेना, but हवालात में चल के. But whether it is havalat or it is outside havalat, you are having a fundamental right to talk to your lawyer or friends or family and tell them that अब my new residence is this. ठीक है? उन्हें बता सकते हैं हम लोग. Right now. Article 22 extends the protection against arrest protection बोला मैंने, no guarantee. Protection against arrest and detention in certain cases. Though it does not guarantee a fundamental right against arrest or detention. And only provides 3 protections to the person arrested or detained. To the person arrested or detained. Article 22 will come into picture after arrest or before arrest? Sir? Write down. Article 22 confers 3 rights. Article 22 confers 3 rights on the person who is arrested oblique detained. First, what is the first protection? Very good, write down. No person who is arrested, please keep reading, समझ के लिखो. No person who is arrested shall be detained in custody without informing him the grounds of his arrest. ये बात होगी that you have to tell him the grounds. Is he actually having fundamental right to talk to his attorney also, sir? आप बताओ. Very good. He shall be entitled to consult. He shall be entitled, लिखो sir. He shall be entitled to consult an attorney. हाँ, same points. He shall be entitled to consult an attorney of his choice. अपनी मर्जी का वकील, attorney of his choice, and defend himself. Supreme Court in Joginder Singh case, 1994. No problem if you do not remember all the cases, but then do not forget the basic cases like केशवानंद भारती में कुछ हुआ, Minerva Mill case, something has happened. Okay, ये तो छोटे मोटे केस हैं, but then landmark cases should not be forgotten. Supreme Court in Joginder Singh case 1994 said that arrested person has the right to have his friends, relatives, or some other known people informed of his ground of arrest. So that he is able to defend himself. Can somebody be arrested just on the grounds of suspicion? No person shall be arrested. शक पे अरेस्ट नहीं कर सकते unless you have some concrete evidence. No person shall be arrested merely on the grounds of suspicion. Merely on the grounds of suspicion. And the arrest shall be recorded in the official diary. You have seen Sarfarosh or not? देखिए ना आपने. When ACP Rathore, he makes an entry into his office for the first time, then he beats a counselor उनको दीवार में. Then he says what? हाँ, नेताजी को अंदर डाल दो मगर अरेस्ट मत दिखाना. Means he is saying do not enter his arrest in the official diary. That was violation of his fundamental right or not? यही समझ लो सर. Next point. Second, the arrested person shall be produced before the nearest judicial magistrate. Nearest. For example, if you live in Delhi and you have committed a crime in Maharashtra, in a particular district, then you will be arrested and you will be taken to a nearest judicial magistrate. Okay. Nearest judicial magistrate within 24 hours of his arrest. Of course, the time of journey, etc. is excluded. Within 24 hours of his arrest. And the third protection which you get as a fundamental right in this right is no person shall be detained in custody beyond the period for which his detention has been authorized. By magistrate. ठीक है सर? You know two things. डिटेंशन दो तरह की होती है. डिटेंशन मीन्स टू डिटेन समबडी इन प्रिजन और इवन आउटसाइड प्रिजन. डिटेंशन टू टाइप punitive and preventive. Punitive detention means what? Crime has been committed and you have been convicted also. Okay, आपका crime साबित हो चुका है and you have been given a sentence. In that case, when you will be detained, you will be under punitive detention. Crime साबित होने के बाद जब आपको arrest किया जाए, that is punitive detention. But then if your crime has not been established and still you have been detained or arrested, that is called as preventive detention. Is preventive detention legal? Yes, it is legal. But then special grounds have to be there. Okay, you cannot just say no, aap aa jao preventive detention mein. You have to give some reasons. What were the reasons, or to prevent what you detained him? For example, there is a kind of ye kya hai? See, if you see this thing, this is kind of violation of right to movement or not? For example, Owaisi, Mr. Owaisi, you know or not? There is a riot broken in Uttar Pradesh and he wants to go there. पहले नहीं जाना है मगर अब now he wants to go there. So we can detain him under preventive detention procedures. उनको पहले ही हम रोक लेंगे, otherwise he will go there and he will spark a violence further, or he might incite, or he might give a lecture or speech which might incite violence. So to prevent that, we will detain him, and then his detention will be called as preventive detention. Okay, these fundamental rights which you have written just now, तीन लिखे ना आपने अभी, 3 fundamental rights you have written or not? For example, ground of arrest has to be given to you. You should be allowed to inform the people. Second, nearest magistrate within 24 hours. Then, nobody can be arrested merely on the ground of suspicion. This will not apply in the case of preventive detention. हाँ जी, अब बोलो. That is not suspicion. Ground is there. We know that violence has actually taken place, and when he will go, he might spark it again. Yes, suspicion देखो क्या है? Crime has committed and you don't have any circumstantial evidence also कि ऐसा हुआ है. Here तो we know historically that he has this habit of giving this kind of speeches. You have some evidence or not? भाई grounds तो बन ही रहे हैं. Already violence has taken place and we know this character of this particular person, that he might give a speech which can incite. Preventive detention. But then historically, this is what I said just now only, historically we know that these people are history cheaters. They have done in past also and they can do right now also because situations are similar. Now this is not only suspicion, this is a kind of anticipation. शक में और anticipation में तो फर्क है कि नहीं है? Write down. Exceptions to Article 22. Under Article 22, the above 3 protections, under Article 22, the above 3 protections are not given to enemy aliens. Aliens मतलब है तो वो धरती की, but then still they are people from enemy territory. Enemy aliens and persons detained under persons detained under preventive detention laws. Twenty-three, 24. ये set of rights है. You tell me, Article 23 and 24 relates to what? Right? Very good. Excellent. Right against exploitation. Okay, 23, 24 somehow relates to your right against exploitation. Article 23, Clause 1. What is it? बहुत बढ़िया सर. Article 23, Clause 1, it prohibits human trafficking and forced labors, जैसे कि bonded labor और बेगार. बेगार you know not. Though it is a Hindi word, but we write in English. बेगार. We make somebody work without payment. बेगार. बताओ सर आप, कोई आपसे बेगार करवा सकता है बिना पैसे दिए? हम तो पैसे देके भी काम ना करें. एक आदमी है जो आपसे बेगार करवा सकता है, but then we will not call it बेगार. State, can state force you to work without you voluntarily asking to do that? State can force you, provided that is in public or nation's interest. ठीक है ना? Right now. Article 23, Clause 1 prohibits traffic in human beings, comma, begars, and other forms of forced labor. इसी का एक्सेप्शन है. An exception to this is Article 23, Clause 2. Exception to Article 23, Clause 1 is this. Article 23, Clause 2. It empowers the state to compel the individual to provide service with or without payment, provided it is in public interest. Do not go into the articles which I have not taken. These are sufficient because they might have subparts. 24, 1, 24, 2, 23, 1, 20, whatever I took in the class, just read them. And along this you read Lakshmikant. साथ साथ कर लो इसको. For example, I discuss Article 14, right to equality. Then you read that from Lakshmikant also. I discuss Article 23, 24. Read that from Lakshmikant also. I did Article 18. Read that from the book also simultaneously. Because see, there are many factual things which I might not be able to take in this 32 or 35 lectures or even in 50 lectures. इतनी चीजें हैं. For example, I ask you, what is the order of precedence? कौन पहले आता है, कौन बाद में आता है? Vice president is this way. You know, there are so many things which are given in the book. So you can go through them and start revising them right now. 24. What is it? बहुत बढ़िया sir. Write down. Article 24 prohibits the employment of children below the age of 14 in hazardous employment. खतरनाक काम. Hazardous employment. 25 to 28, हाँ जी आप बताओ. Right to 25 to 28, right to freedom of religion. Okay, 25 से 28 क्या है ये? It relates to freedom of religion. Let me tell you, it is highly important. Not religion, sir. Article. Okay. Write down this. Anybody, what is Article 25? You write down and then I'll explain. And while writing, keep reading also. लिखो इसको पहले. Article 25 guarantees a twofold freedom of religion. Twofold मतलब double or two step. Twofold freedom of religion. First, right to freedom of conscience. इसे what is this conscience called in Hindi? हाँ, अंतरात्मा और ज़मीर. उर्दू भी बोलनी चाहिए कभी. ओके, अंतरात्मा और ज़मीर, मन की आवाज. ठीक है सर. Right to freedom of conscience. Second, right to profess. Professor, from professor this word has come. Profess, practice and propagate a religion of one's choice. Sir, what is this right freedom of conscience? बताओ. अभी आपने खुद ही बोला अंतरात्मा. बताओ. It is like freedom of speech and expression. यही सर डिफरेंस आ जाता है. सी, यही तो डिफरेंस है. कॉन्शियंस एक ऐसी चीज है. कॉन्शियंस इज समथिंग विच यू नेवर वांट टू डिस्क्लोज और एक्चुअली वांट टू हाइड. अब एक बात बताओ, अंतरात्मा में आपकी बहुत सारी बातें चलती होंगी, बहुत सारे विचार आपने स्टोर करे होंगे. डू यू डिस्कस देम विद एवरीबॉडी? मन की बात मन में ही है, एंड थैंकफुल इट इज इनसाइड ओनली, एंड नोबडी एल्स कैन रीड देम. बट देन सी, डू यू हैव दिस फंडामेंटल राइट ऑफ कॉन्शियंस? यस, ये तो आपने लिखा ही है. कैन स्टेट पुट अ रेस्ट्रिक्शन ऑन योर राइट टू कॉन्शियंस? नो. स्टेट को कैसे पता चलेगा? This is not so simple also. Conscience means your orientation towards particular kind of thinking. ये बहुत critical है. You see that way. If you go into deeper to this, conscience means I have a particular religious orientation. और वो मेरे विचारधारा है. It is inside me only. I have not disclosed that in form of my words or in the form of my practice. मन में मेरी कुछ भी बात हो सकती है. And state cannot put a question on that. अब see, I take you a very sensitive and critical example. For example, in my conscience, there is a kind of feeling that I should or I support a particular kind of organization which is highly destructive, having a religious orientation. ISIS मान लो, ठीक है? ISIS ये मन में ही है. You have not said anything to you. I mean, internally you feel, no, that is a kind of religious organization. This is doing it. Is this banned actually? No. This is not banned because nobody can actually ban that unless you tell it outside to people. कोई अंदर थोड़ी ना झांक सकता है. So you have this freedom of conscience. You can have any kind of orientation regarding religion. You can feel, see, this is focus on words. You can feel, you can think that this religion is good, that religion is bad, every religion is bad, I better be atheist. ठीक है ना, नास्तिक बनने में कोई बुराई नहीं है. This is my conscience, this is going in my head, this is the way I think, but you are yet to know this. And I am completely free regarding this. State cannot control or manipulate my conscience. मेरे अंतरात्मा को वो छेड़ नहीं सकता, उसको पता भी नहीं चलेगा. Second is this. अब अंतरात्मा आ गई बाहर. बोलो सर, आपके मन में बहुत विचार चल रहे हैं. Will you actually convert those thinking to words? करोगे? Some point of time you must have done also. Conscience, it will come out in the form of words. For example, you are a follower of a particular religion. You start chanting or you start speaking something in the favor of that particular religion. और आपका religion है, I do not believe in any religion, I am an atheist. You will keep saying it's better to be an atheist than follow this religion and then fight with other religion. ठीक है, ये आपने बोलना शुरू कर दिया. Means you are spelling out, मुंह से बोल रहे हो. And the second form of this is, पहले तो आप बोलते हो, फिर क्या करते हो, फिर करते हो. Okay, practice. For example, you become inclined towards a new religion, और आपने खुद ही एक religion बना दिया. Then you spell out this, that this is the way I feel about this religion. Then you also practice the religion or not. Every religion has got some rituals. उसको practice करना शुरू कर दोगे आप. After practicing it, what is the third stage? Propagating. अभी तक तो खुद practice कर रहे थे. Now you are asking others also. वहाँ क्या religion है? You also join it. This is called as practice. मतलब in Hindi, it is called as this. फैलाना. Okay. बोलना और वाचन. Okay. लिखो. Freedom of conscience means they can make a question out of any word. Freedom of conscience means absolute. Freedom of conscience means absolute. Is right to freedom of religion absolute? No. But freedom of conscience is absolute. Remember this. Freedom of conscience means absolute inner freedom of an individual to mold his religious belief and faith. When this inner freedom takes an outward expression, जब अंदर की बात बाहर आ जाए, takes an outward expression, it brings into discussion right to profess, practice and propagate a religion of one's choice. First, right to profess क्या चीज है? Right to profess is the right of an individual. Right to profess is a right of an individual to spell out, बोलना, to spell out his religious belief openly and freely. Second, right to practice is the right to follow. Right to practice is the right to follow the rituals of the religion अब रिचुअल में तो दिस इज ऑल्सो रिटन दैट यू हैव टू वेयर बुरका ये लिखा है उसमें विल इट बिकम योर फंडामेंटल राइट यस आई टोल्ड यू प्रीवियसली ऑल्सो wearing the sign of religious denomination जैसे कि veil or you can have this kada or kripan also okay these are your fundamental right because they are not actually your personal belongingness they are your symbol of religion right now. Displaying the symbol and signs associated with the religion is part of it. You can give example also cross, turban, kirpan, veil, कुछ लोग वो भी जनेऊ okay right to propagate means right to propagate means right to spell out the religious teachings for edification. What is edification? Yes, edification means you are creating a foundation for others to come and stand on. For example, I might just give you some lecture on a particular religion. Deen-e-Ilahi क्या जबरदस्त वो है religion है. You come, you know about Deen-e-Ilahi. This is it, this is it, this is it, and you became so much influenced by that. You joined the religion itself. ठीक है ना? I did not tell you that you join it, but I propagated it. Dharm Sabha are being called for that only or not? People are invited free of cost. उसमें चाय पानी भी देते हैं. Why? So that people can come, have patience to sit there and take the lecture and go back with a new religion. Okay, we don't ask them to get converted, but then they get influenced by that. This is propagation. I have this right. Write down. For edification of others. In 1977, change the paragraph and then write. In 1977, Supreme Court said, Sir, do you have the fundamental right to convert others? भाई right to profess तो है ही है. Forcefully नहीं करना है. Very good, बहुत बढ़िया. Write down. In 1977, Supreme Court said, देखो बहुत अच्छी लाइन है. The fundamental right of a person to transmit or spread his religion, by explaining the content, of course, of the religion only. By explaining the content cannot be questioned. अगर वो समझा रहा है कि religion में ये लिखा है तो no problem in that. Fundamental right of a person to transmit or spread his religion by explaining the content cannot be questioned. However, there is no fundamental right. To convert others to one's own religion. Supreme Court also made a distinction. Supreme Court also made a distinction between religious faith, एक ज्ञान और दिया, between religious faith and belief. Between religious faith and belief on one hand, and conduct and practice on other. Sir, एक बात बताओ, tell me one thing. What do you feel? There is on one hand religious belief and faith of yours. You also have religious conduct and practice right. Which right can be controlled or regulated by state? Both. Conduct and practice. Cannot state actually control this religious belief and faith? No. Very good. This was said by Supreme Court. और उन्होंने बोला ये difference भी है. Do not mix them. Write down. In case of faith and belief, in case of faith and belief, in case of faith and belief, the fundamental rights enjoyed by the individual, fundamental right enjoyed by the individual is absolute. And state cannot interfere in any manner. But state can regulate religious conduct and practice in public interest. Example, जब सुबह सुबह भजन होते हैं 8 बजे तो it creates lot of disturbance.
during some part of the year, सुबह 5
बिल्कुल सही बात है,
गर्मी में जैसे रात गुजरात में भी था.
बिल्कुल. दो सुबह 5 बजे you should have got out from the bed, but आप सो रहे हो. When there is bhajan, it disturbs you or not? और जागरण, do you now see जागरण happening? Do you actually ever saw जागरण? देखे ना आपने? बहुत अच्छे होते थे. In the morning they used to give you prasad also. At 2 o'clock also they used to give you tea and some snacks. पेट पूजा बड़ी सही होती थी. But now there is a ban or not? Reason being, regulation of religious faith, religious conduct and practice has been done by the court. Because many people were getting disturbed. For the whole night, your neighbor is carrying out this jagran and he is taking away all the punya of that thing, and you are paying the price or not? कल एग्जाम है, उसको तो पुण्य मिल गया, आपका पेपर चला गया. So state banned these kind of activity, and it was a regulation of religious conduct and practice. ठीक है sir? Next, Article 26. What is it? Write just one line on it. Deals with, Article 26 deals with freedom to manage, deals with freedom of a religious denomination. लिखो. Deals with freedom of a religious denomination to manage religious affairs. सारे रिलीजन अपने प्रैक्टिस खुद डिफाइन कर सकते हैं. Subject to public order. Subject to public order means it should not hurt public order, morality, and health. And health. Why this article became important some time back? Sabrimala health. Fire? Fire safety है. Santhara. Santhara is a practice, no, practiced by Jain people, whereby they stop taking food till they die. Now some people said that this is against their health and they should be stopped. Because they are managing the religious affairs. ठीक है, Jains have this practice of having Santhara, agreed, we don't have any problem. But it brings negative consequence on the health of the person practicing it. वो तो मर ही जाएगा. And this is also against his right to life. Though state is not taking this right to life, तो इसलिए I am not discussing right to life, because right to life enforceable कहाँ है? State थोड़ी ना उनको मार रहा है. Nor any other person is doing so, but he himself doing so. भाई why? देखो, I am saying Santhara cannot be seen like a violation of Article 21, because in right to life nobody else is asking her to do this, or not state is asking her. Right to life तो enforce होता है ना किसके against? state or private individual. But then in this case, he or she is himself giving her, or I mean bringing problem on his health parameters. So therefore I am not using this word article 21. Article 26 लग सकता है इसके ऊपर. Understood or not? This can go against the health parameters of a person conducting it. So we might regulate it, though we did not at this point of time, right now. Subject to public order, morality and health. Article 27. Sometimes they ask article also in examination. वो लगा देंगे list. Article 27. What is Article 27? No taxation of a religion. But then don't we spend taxation amount on Hajj Yatris also, Kumbh Mela also? They do it fairly on everyone. देखो, Article 27 says that state cannot spend the tax amount on the welfare of a particular religion. Particular religion पे नहीं करना है. You can do it on all. ठीक है ना? भाई state has got some funds or not? Where from those fundings are coming? वो कहाँ से आते हैं? Taxation से. Now state cannot use that money for the welfare of only Muslims or only Hindus or only Christians or only Sikhs. It can be or it is to be used for the welfare of all the religion equally. Write down. Article 27 truly spells out, very critical line, Article 27 truly spells out, practically, truly spells out the secular character of the state. Question can come, which article actually spells out the secular character of the state? Article 27 truly spells out the secular character of the state. It prohibits the state from spending tax collection for the promotion and maintenance of all the religions. Sorry, it prohibits for the promotion and maintenance of a particular religion. Though it does not prohibit the state from spending tax collection for promotion and welfare on all religious tax collection on all religious denomination. Tax collection for the promotion and maintenance of all religious denominations without discrimination. Without discrimination. Is there any condition by which state can spend money on the welfare or upliftment of only one religion? ऐसी कोई condition है? See, if the money is coming from charity or donation from a particular religious denomination, that can be channeled only for the religion. समझ रहे हो? For example, if I give in charity to state, I have for example crores of rupees and I give it to the state, that state you please manage my fund for the welfare of Hindus only, then state is allowed to do that. क्योंकि वो that money is not coming from tax collection, that money is coming out of charity or donation. Right now. Article 27 does not prohibit. Article 27 does not prohibit the state. Article 27 does not prohibit the state from spending non-tax collection collected in the form of fee, or donations for the welfare or promotion even of a particular religion, Article 28. After 28, how many left? 4 or 3? 3. 31 has been removed, sir. Right to property था ना? Yesterday तो कल बताया मैंने आपको. Hindi English mix. Yesterday तो कल बताया. Article 28. See, what is Article 28? एक बात बताओ सर. For example, गायत्री मंत्र. It relates to Hindu religion. Let's assume that for some time. Can we force students who are coming from different religions in a school to recite गायत्री मंत्र? जबरदस्ती कर सकते हैं? पहले तो उसके लिए याद भी होना जरूरी है. But then, if you can tell them that recite this way, you cannot force them. Or can you force them in any situation? Yes, they can be forced in one situation. Otherwise not. ठीक है ना? Write down. एक situation है जहाँ force भी कर सकते हैं. What is the situation? If that school is managed by, पैसा जो आ रहा है वहां से आ रहा है. Write down. Very good. Article 28. Article 28 deals with imparting instructions in educational institutions. It divides educational institutions in 4 categories. 4 कैटेगरी में डिवाइड करता है. फर्स्ट, एजुकेशनल इंस्टीट्यूशंस that are completely owned, O-W-N-E-D, owned and administered by state. Funding is also coming from state and management is also of state. So, for example, sarkari school, in government school, can you force somebody to recite a particular religious lines? Force कर सकते हो आप किसी को? No. Because state is secular. ठीक है ना? Write down. Here no religious instruction whatsoever can be imparted. Means the educational institutions which are, listen, educational institutions which are completely owned or managed by state, there you cannot force or even give religious instructions. Okay, next type of educational institutions. Educational institutions that receive aid, AID, that receives aid out of state's fund. State उनको पैसा देता है. That receive aid out of state's fund means there is a school X. एक school X है. It is owned by me. It is managed by me. But state is giving me some fund to run the school. In this school, can I force the students to learn the religious instructions and also spell them out? For example, Gayatri Mantra, can I force them? Rato aur fir bolo. No. Can I give them educational instructions which are religious in nature? दे सकता हूं. सरकारी स्कूल में can we give religious instructions? No. In the institutions which are owned and run by state completely, there you cannot even give religious instructions. Leave aside forcing. Whereas in these institutions which are not owned and managed by the state but are owned by somebody else, but they are getting funding from state, aid मिल रही है उनको, aided school बोलते हैं ना जिनको. Here you can give religious instructions, आप दे तो सकते हो, but somebody can deny, नहीं मैं नहीं बोलता, then you cannot force him. Write down. Educational institutions that receive aid out of state fund, और इसी के नीचे, this was the category B. Below this you write category C also. Educational institutions which are unaided, means they are not getting aid, which are unaided but are recognized by state. उनकी existence को state recognize करता है. In above two categories, मतलब ये B और C जो category है, in above two categories, religious instructions मतलब religious education or religious instructions can be imparted, दी तो जा सकती है, but what cannot be done? Force नहीं की जा सकती. Can be imparted, but students cannot be forced or compelled to attend them. ठीक है सर? For example, आप affiliated नहीं बोलते हो. Your school is affiliated to this board. A state is, for example, you conducted an exam. After that, you want to go to have an admission in some college. The college will say, no, your school is actually not recognized by the state itself. आपने खोल दिया श्यामलाल Senior Secondary School, and you are running it without even registering it with the state or getting recognition from the state. This is not the case, sir. ठीक है? Sometime you need not even do that. Fourth, institutions that are administered by state but were established, institutions that were administered by state but were established by religious endowment. Endowment means kind of funding only or support. Religious endowment or charitable trust. Means an educational institution, a school A, is running because of the support coming from a religious trust. Can we give religious instruction there? Yes. Not only we give religious instructions, we can force also. Okay, if you want to study here, you recite the religious lines. वरना हम निकाल देंगे. Because that school is being run by whom? Religious endowment completely. Their religious instructions can be imparted and be made compulsory also. Made compulsory also. मदरसा ले लो फॉर एग्जाम्पल, है कि नहीं है? यू कैन नॉट डिनाई, नो आई विल नॉट रिसाइट दिस पर्टिकुलर इस्लामिक इंस्ट्रक्शंस. आपको बोलना पड़ेगा, अदरवाइज इफ यू डोंट वांट यू कैन मूव आउट. ठीक है? आर्टिकल 29 to 30 क्या है ये? Article 2930 umbrella term is cultural and educational rights. अभी आर्टिकल 29 क्या है? सी माइनॉरिटीज, यू नो माइनॉरिटीज का मतलब क्या है? Where in the constitution the word minority has been defined? Nowhere. If you see constitution, nowhere it is defined what is minority or who all are minority, ठीक है ना? But then in number of pronouncements we came to know that these category of people will be called as minority. But generally minority means numerically a group which is less than 50% or which is not in majority. If there are 100 people living in an area, if you belong to a religion community where only 30 people are there, then you are a minority. ठीक है ना? Or even if in a locality only 2 religion communities are living and you are 49 and they are 51, then you can be called as minority. You can be बोल रहा हूँ मैं, because there is no definition. ठीक है? And what the meaning of minority in this constitution is, 2 kinds of minority they are talking about. One is religious minority होती है, the other is linguistic minorities. Linguistic means language. Some language, for example, in India, let's say if the population is 100 and there is only one speaker of a particular language X, then he will be called as linguistic minority. Hindi. People speaking Hindi, are they member of linguistic minority? No. बहुत सारी population है उसका. ठीक है? So the word minority, when we discuss in the context of Article 29 or 30, we mean only 2. ये question आया है, this question has come in exam. Linguistic and religious minorities. Scheduled caste, will they be called as minority? Otherwise they will be called minority? No. They will not be called as minority. Supreme Court has clarified this. There was an ambiguity earlier, but Supreme Court clarified, so scheduled caste will not be considered as part of minority because they are integral part of Hindu community, and Hindus are not minorities, they are majority. इसमें write 2-3 lines and then I'll explain. Article 29. देखो, Article 29, the language, when you open the constitution and you see Article 29, then it says, title क्या बोलता है उसका? It has used the word minorities. मतलब means Article 29 relates to, I mean, it has a provision regarding minority. But then if you see the language of Article 29, it is not only extending protection to minorities, it is giving protection to everybody who has a different language or script. अभी I'll explain right now. Article 29 में लिखो, though the title of Article 29, though the title of Article 29 is protection of interest of minorities, the language of Article 29 clause 1 actually extends this right to all sections of citizens residing in India. Now see the language of Article 29 clause 1. Uski language dekho. This is the language. See, write down. Any section of citizens. He is not using the word minority itself. Any section of citizen residing in India having a distinct means unique or different, having a distinct language, script or culture of its own shall have the right of its own, apna, shall have the right to conserve the same. मैंने क्या बोला? Article 29, the title is, this benefit is given to minorities. But then if you read the article itself, you will come to know that this benefit is not only given to minorities, it is given to everybody, even including majority. And minority matlab religious and linguistic minority. And now see this case, Maharashtrians. Are Maharashtrians linguistically a minority? They are not. बहुत सारे लोग मराठी बोलते हैं. But then when these people, they go to, let's say, West Bengal, will they lose this right? भाई वो linguistically minority में तो नहीं आ रही ना. But then still when they go, for example, they go to West Bengal, will they not have this right to conserve the Marathi language? Yes, they will have this fundamental right, even if they are not considered to be in minority. Marathi को linguistic, it is not linguistically minority. Marathi people are not minority. Linguistic minority थोड़ी ना है वो लोग. But then even when they go to Bengal, for example, or they come to Punjab, they will have this right to conserve their language. यही आपने लिखा है, that this right gives protection. Do not write, listen. This right gives you protection even if you are not a minority explicitly. तब भी you have this right to protect your language, culture and script. For example, I carried out a protest that I want my language to be included in UPSC examination. Example दे रहा हूँ. And I carry out a protest. और आप सबको भी अपने साथ ले लिया after teaching you the language. ठीक है? Will that protest be illegitimate? I am protesting to save my own language. Will that be illegitimate? No. Till the time I am doing a peaceful protest, that is not illegitimate, because I am asking the state to protect my distinct language. मैं अपनी language को protect करने के लिए अगर protest कर भी रहा हूँ, so it is not illegitimate. This happened in India or not? हुआ था कि नहीं हुआ था? Southern states, Tamil Nadu, there was a huge protest or not? They were asking that English or Hindi should not be forced on us. The status of Tamil language should be respected. And there was a mass protest. So that was appreciated, because they had this right to conserve their language under Article 29 Clause 1. यही अभी आपने लिखा. Even if you are not a minority, you have this right to conserve your script, culture and language. Next, 29 Clause 2. Anyone, what is 29 Clause 2? Very good. Article 29 clause 2 is regarding admissions into educational institution. Can there be a ground of discrimination in case of giving admission to an educational institution? On few bases. What? Residence is a ground or a place of birth? Or any other ground also? क्या सर? नहीं, रिलीजन नहीं है यार. एक बात बताओ, यू आर अ बॉय और नॉट? बताओ है ही. कैन यू टेक एडमिशन इन अ गर्ल्स स्कूल? इवन इफ यू वांट, चाह कर भी नहीं ले पाओगे, बिकॉज सेक्स इज अ ग्राउंड टू डिस्क्रिमिनेट while giving admission in educational institution. ठीक है सर? राइट डाउन. 29 clause 2, no citizen shall be denied. Remember citizen. No citizen shall be denied admission in any educational institution maintained by state or receiving aid from state's fund, only on the grounds of, सिर्फ इसी ग्राउंड पे कोई रोकेगा नहीं आपको. Religion is one of the grounds. Only on the grounds of religion, race, caste, language, okay. So I mean, what I mean to say is that sex can be a ground of discrimination here. Even place of birth can be a ground of discrimination here. ठीक है ना? Article 14 में we write that or not? religion, race, caste, place of birth, sex. So place of birth and sex has been removed with this clause. Article 30. We are about to conclude. Article 30. What is it? बहुत जबरदस्त. This kind of ratification is required, truly. And this is not in a negative sense. Everybody should have this ready with you. Again, I am saying this, reason being, I have seen many people suffering because of this thing only. Kar lenge aram se. Now, this is the time. After, going through these facts, after committing these facts to your memory, you should have some time by which you can do some analytical thinking also, by which you can do analysis and counter-analysis of a situation. For example, yesterday I discussed flag hosting. Is it allowed or not? Can you hoist the flag of Pakistan or not? What is right, what is wrong, you should be able to think yourself, and that will come analytical thinking once you are through with your facts. Facts ही याद नहीं होंगे तो क्या analytical thinking होगी? Okay, right now. Article 30 deals with right of minority community. Minority means religious or linguistic or both? Both. Right of minority community to establish and administer educational institution. Minority can be, you write down, otherwise you'll forget. Minorities can be linguistic or religious. Recognized at center or state level. Center की अपनी list, state की अपनी list. Recognized at center and state level. Article 31A. Minority educational institutions. Minority educational institution enjoy right to property. See, right to property is not a fundamental right, but then this is an exception. If you are running a minority educational institution, for example, if you are running an educational institution for Muslims, ठीक है sir, you are running an educational institution for Muslims, then only you will have the right to property. अब still एक बात बताओ, for example sir, you are manager of a particular trust which is running a religious institution. Muslims के लिए एक मदरसा चल रहा है. You have this right to property. Can anybody acquire that property also? No, ये तो right to property है. But then there is always a one person who can acquire this. Who is that one person, sir? State. सरकार ले सकती है. By giving compensation or without giving compensation? Of course, by giving compensation. जैसे for example metro जाना है वहाँ से, okay? Or there can be some other reason also. Write down. Article 31A, minority educational institutions enjoy the right to property, though state can take over. Though state can take over such property in public interest by giving due compensation. By giving due compensation. Supreme Court in T. Inamdar case, Supreme Court in T. Inamdar case 2005 said, please read what you are writing, I'll explain after that. Said that since unaided educational institution held that unaided educational institutions Unaided, please underline the word unaided. Circle भी मार सकते हो, you can encircle it also. Unaided educational institutions are the educational institutions which are not receiving fund from state. Support नहीं मिल रही, वो अपने आप चला रहे हैं. Unaided educational institutions, whether minority or non-minority, in character, वो माइनॉरिटी इंस्टीट्यूशन है या नॉन माइनॉरिटी है, दैट हार्डली मैटर्स. इफ इट इज अनएडेड तो क्या होगा? सर यू आर रनिंग अ स्कूल एक्स, एक स्कूल एक्स चला रहे हैं ये. दिस स्कूल एक्स इज नॉट गेटिंग एनी सपोर्ट फ्रॉम स्टेट, फंडिंग नहीं मिल रही है इसको स्टेट की तरफ से. ओके, एंड दिस इज अ काइंड ऑफ लेट्स से हिंदू एजुकेशनल इंस्टीट्यूशन. ओके, एक हिंदू एजुकेशनल इंस्टीट्यूशन है बट नॉट गेटिंग सपोर्ट फ्रॉम स्टेट, एड नहीं मिल रहा है. Will you have the right to chart out your own rules of admissions? ये fundamental right होगा आपको, और this right will be given only to somebody who is running a Islamic educational institution. वो तो minority में आ जाते हैं, आप तो majority हो. Unaided है. He is running a majority educational institution, मतलब हिंदू का education institution चला रहे हैं, but since it is unaided, he will get the right to run in his own way. ये इनका फंडामेंटल राइट होगा. इफ ही फील्स लाइक आई विल नॉट गिव रिजर्वेशन टू ओबीसीज, ही कैन डिनाई दैट. सी अंडरस्टैंड दिस वेरी केयरफुली. दिस इज अनएडेड स्कूल, पहली बात तो. नाउ वेदर इट इज माइनॉरिटी और नॉन माइनॉरिटी, उससे फर्क नहीं पड़ता है, ये सुप्रीम कोर्ट ने बोला. अनएडेड एजुकेशन इंस्टीट्यूशन वेदर इट इज ऑफ माइनॉरिटी नेचर और नॉन माइनॉरिटी, चाहे वो हिंदूज का है या इस्लामिक है या क्रिश्चियन, दैट कैन डिसाइड इट्स ओन रूल्स ऑफ मैनेजमेंट एंड एडमिशन. एडमिशन किसको देना है, कैसे देना है, दैट कैन बी डिसाइडेड बाय हिम, प्रोवाइडेड दैट इज फेयर. वो नेचुरल जस्टिस लगे उसके ऊपर. इट शुड बी फेयर इनफ. आई मीन ही कैनॉट मेक जस्ट एनी XYZ रूल विच इज अनएथिकल. ऐसे रूल नहीं बनाएंगे. But then if till the time he is making fair rules, he can make his own rules. If he says no, I will not give admissions to OBC, okay with him. We also agree with that. Okay, now this was said by Supreme Court. In which case? T Inamdar case 2005. No problem if you do not remember the case. उससे कोई दिक्कत नहीं है. अब देखो एक बात हुई. Judiciary gave a judgment. To cut the judgment, what can Parliament do? Amendment. पार्लियामेंट एक अमेंडमेंट कर देगा दैट दिस रूल विल अप्लाई नॉट ऑन माइनॉरिटी कम्युनिटी, दे कैन हैव देयर ओन रूल्स ऑफ एडमिशंस. ठीक है ना, राइट डाउन दिस. इन टी इनामदार केस सुप्रीम कोर्ट सेड unaided educational institution whether minority or non-minority in character enjoy unaided educational institutions, whether minority or non-minority in character, enjoy a fundamental right to choose the procedure of admission till the time it is what? Fair. Very good. Fair and transparent. जब तक वो सही है तब तक ठीक है. Besides the policy of reservation, of SC, ST, OBC, in which article did you read that even backward communities can have reservation in educational institutions? बहुत बढ़िया है. 15 clause 4, 15 clause 5. Yesterday we did this, that reservation can be provided even in educational institutions. है कि नहीं है? Using that power, Parliament amended the Constitution or not, and they also gave reservation to OBCs in central educational institutions. 27% reservation. ठीक है ना? The Supreme Court actually tried to nullify this. Write down. Besides, the policy of reservation of SC, ST, OBC cannot be enforced in unaided educational institution. ये सुप्रीम कोर्ट ने बोला. भाई पार्लियामेंट देखो आप, लेट मी समराइज दिस. पार्लियामेंट, बी क्विक, लुक एट मी. पार्लियामेंट मेड एन अमेंडमेंट इन द कॉन्स्टिट्यूशन. दे इंट्रोड्यूस व्हाट? आर्टिकल 15 क्लॉज 5. उससे उन्होंने क्या बोला? दैट वी विल गिव रिजर्वेशन इवन टू बैकवर्ड कम्युनिटीज इन एजुकेशनल इंस्टीट्यूशंस, इंक्लूडिंग प्राइवेट एजुकेशनल इंस्टीट्यूशंस. वहां भी हम रिजर्वेशन दे सकते हैं. बट देन उससे हुआ क्या? सुप्रीम कोर्ट ट्राई टू नलिफाई दैट. सुप्रीम कोर्ट गिव एन ऑर्डर इन ती इनामदार केस दैट यस you can give reservation, but if the institute is unaided and this is minority or non-minority, they can choose their own procedure of admission and they can deny giving reservation to OBCs, SCs and STs. वो मना कर सकते हैं. यही अभी आपने लिखा है. Means they try to nullify the action of legislature or not. एक तरफ on one side legislature tried to give reservation in education institutions to backward communities. On other side, in this case, judiciary did what? It nullified. It said completely that if the institution is unaided, चाहे वो minority है, non-minority है, unaided education institutions can have the right to choose their own admission procedure, provided they should be fair and transparent. And in this case, 15 clause 5, वो जो reservation है SC, ST, OBC को, that will not apply also, right? But then now it is turn of parliament. अब parliament का turn है to nullify the judgment of judiciary. Parliament देखो, what you wrote, SC, ST, OBC cannot be enforced. Complete the sentence. Reservation of SC, ST, OBC cannot be enforced in unaided educational institution. ये हो गया? Write down. Now Parliament passed. अब Parliament की बारी है. Now Parliament passed which Amendment Act? Very good, sir. Excellent. बहुत बढ़िया. 93rd Amendment Act. Now Parliament passed 93rd Amendment Act. Which year? 2005. Under which reservation policy in favor of SC, ST, OBC have been extended in admissions to unaided non-minority educational institutions. Means this category will now be forced to provide reservation to backward communities. ये जो non-minority institutions हैं, even if they are unaided, they will have to give reservation to backward communities. They cannot say no, we have a fundamental right by which we can choose our own procedure of admission. वो fundamental right तो है, मगर reservation देनी पड़ेगी आपको. Understand this or not? And this is true because of this amendment. Parliament ने साफ साफ लिख दिया. You have the right to manage your own admission process, but still you have to give reservation to SC, ST, OBC, provided you are a non-minority institution, unaided also. अगर आप minority हो, then will you be forced to give a reservation? No. If you are a minority educational institution, minority linguistic or religious, if you are a minority educational institution and you are not getting aid from state, then you will not be forced to give reservation to SC, ST, OBC in admissions. मगर अगर आप non minority हो तो देनी पड़ेगी as per this amendment. Okay, write down last article 32. Nature, article 32. सर आप कल पढ़ के आना. After it is being done, do not ask me this thing. In fact, I should be asking you this thing. And the last article, Article 31 तो remove हो चुका है, right to property. Article 32. Why I say last article? Because this is the last fundamental right. The remaining are subsidiary clauses. Article 32. What is it? Article 32. Quick. Constitutional remedy means, let me tell you simply, we can have a thorough discussion tomorrow. Simply it means if your fundamental rights have been violated, अगर आपके fundamental rights को कुचला है, किसने सर? State ने या किसी और ने भी? Private भी यार. If your fundamental rights have been violated by state or even individuals, then you can approach Supreme Court directly. And Supreme Court will then issue orders or writs, WRITS, writs is kind of an order only, issue order or writs to restore your fundamental right. For example, police kidnapped you without even giving you the reason, and they are not allowing you to talk to your family also. Then is it not your violation of fundamental rights? Which article? हमें क्या लेना? कल बताना. If your fundamental right has been violated by police, then you can move directly to Supreme Court. Of course, you yourself cannot go because you are in custody. Somebody else on your behalf will go, and in response, Supreme Court will issue an order in the form of writ, which is called as habeas corpus, and by which it will direct the police, release this body, इस आदमी को release करो. This is done under Article 32. Article 226 is the same power given to High Court. Means, do not write, just listen. Tomorrow I'll dictate. Means, if somebody's fundamental rights have been violated, then he or she can approach the High Court, or somebody else on his behalf can approach the High Court, and then they can file a petition, and in response, that High Court will give a direction to the body to restore his fundamental right. For example, आपको पुलिस ने अगर पकड़ लिया है for wrong reasons, पुलिस छोड़ो बार बार, why should I take example of police? Let's say UPSC. 7th August exam. On 3rd August, suddenly you were waiting for an admit card. Admit card did not come. You said, yeah, what is the problem here? You were busy studying. Admit card तो आ ही जाएगा, उसकी क्या tension है? You were busy studying. You did not even check the status. Suddenly you opened the status online. You saw your form is rejected. Violation of fundamental right or not? I mean, आपके साथ नहीं हो रहा, but then this has happened with somebody. So I am saying this. Then he or she will approach High Court, Supreme Court, or any other court. That is his wish. If he is approaching, by right to vocation गया कि नहीं गया? You wanted to earn into a public, enter into public service, but denied. Hall ticket issue नहीं करा आपको उन्होंने. Then you will approach Supreme Court or High Court, your wish. If you approach Supreme Court and Supreme Court restores your right, वो UPSC को order देता है भाई issue him the admit card, then that is the power under Article 32. If you go to High Court give direction to UPSC, release his admit card, then you are High Court is doing so under Article 226. Can High Court say, no, I will not give this direction? Yes. High Court can say this, I will not restore your fundamental right, but this is not the end of the story. High Court will pass on the case to some other body. कि भाई तुम देख लो. But then High Court, for example, it does so that वो CAT को बोलता है. CAT is Central Administrative Tribunal. High Court will tell CAT, or it will pass on your case to CAT कि भाई आप CAT में चले जाओ. They will help you get justice. I will not give you justice in this case. But then Supreme Court cannot say so. High Court मना कर सकता है आपको direct justice देने से. But Supreme Court cannot say no, take this case to some other court. Because under Article 32, Supreme Court is bound to give you justice if your fundamental rights have been violated. But under Article 226, High Court is not bound to give you justice if your fundamental rights have been violated. But then it will not leave you that way only. It will provide you some avenue to get justice. That avenue can be CAT, that avenue can be JAT, that avenue can be some other subordinate court or whatever. ठीक है, tomorrow I'll take up in detail, and this article is called as the right to constitutional remedy. So no, do not pack the bags. Last line, constitutional remedy. Remedy का मतलब क्या है? Remedy मतलब इलाज. If your constitutional rights have been violated, then you will get remedy from Supreme Court and High Court under the Article 32 and 226. Okay, thank you very much. We continue tomorrow.